now being joined by lawyer and Arise news analyst Frank Tietie. Good to see you and thanks for your time. Well, finally, this is coming before the swearing in. What's there's a lot of absence of what you listen to Orji Kalu here. He was talking about the southeast of the country where there's been some vacancy for that long, but finally here we are. What would this mean in our dispensation of justice?
Well, it will simply enhance the sense of balance, a sense of fairness, a sense of not having a feeling of exclusion that has always greeted the minds of persons from the southeastern part of this country. It stayed for too long. It was embarrassing, more especially when the Constitution encourages the president not to waste time to ensure that he appoints justices to the number of 21. And for a long time, at the time, it was less than half of the number. So just about half of the number. So that wasn't good because there was no basis for such long vacancies. So this is a welcome development.
Right. I mean, it's good to know that Nigeria now has, the statutory requirement of 21 justices of the Supreme Court. But the question is it the approval of their nomination or their appointment? Help us understand. I mean, is there any difference between those two?
Yes, indeed.
Right.
Yes. The difference is clear. The Constitution mandates the President under Section 231 to appoint on the recommendation of the National Judicial Council. It's a very funny relationship, meaning that, does it mean that it is the Chief Justice of the Federation that heads the NJC that will go shopping, that will conduct interviews for certain personalities who are lawyers, who have at least 15 years of experience and then recommended to the president for appointment? Or like one thing that is probably debatable and faulty with regards to this set of justices that have just been appointed, in the sense that they were all elevated straight from the Court of Appeal, which is something that watchers have considered to be a misnomer, and that will not be helpful, because we've had a history of a very robust Supreme Court that has jurists, academics, and persons who have displayed international prowess in legal jurisprudence that have been appointed to the Nigerian Supreme Court. So to think that that is the Constitution says is the president that does the appointment, and then it moves on to the Senate to do a confirmation, which many watchers consider to be unnecessarily hurried, and again does not serve the judiciary well. The judiciary, in my opinion, missed a very golden opportunity by not allowing Nigerians to participate in a worthwhile confirmation process. So Nigerians should have watched that on live television, because we seem to always find a way of shielding the judiciary from some form of public scrutiny. Live broadcast of the confirmation process would have been very helpful. Judiciary missed it because Nigerians ought to, like we see in the politics of the confirmation process from another sister democracy in the United States, where you actually interrogate the persons who have been appointed into your Supreme Court, knowing their nuances in terms of basic issues and all that, so that you know what to expect, because law is meant to be predictable and not to be confusing the way we have seen it so in recent time. Judiciary has been in the eye of the storm. That would have been an opportunity if there was a live telecast of a fairly lengthy, devoting maybe a week or two to the confirmation process, of giving a day or two to each of those justice nominee. Unfortunately, we didn't see that. So there's too much politicization in the appointment of judicial officers in this country, and we shouldn't then be surprised at the outcome, because the outcomes are always considered to be tainted by some political inclination. That shouldn't really be, more especially when you consider that they don't write qualifying exams, they don't actually go through a serious scrutinizing process. All you need to do is just be a lawyer, remain in the bench if you want to, or practice law for 15 years for the case of Supreme Court, or 10 years for the case of High Court. So I think what has happened is I think the judiciary missed it, and the Senate in this horrid process didn't quite help the situation.
How possible is it for us to remedy it? Because the aspect of televising is very key here. And again, quickly, it's been a long time. We haven't seen justices picked from the academics.
It's sad. I must
because we've seen some of those finest judges, justices, come from the academy.
No, look, in fact, you don't go too far. Just take the example of Teslim Elias, who not only practiced law, he taught law. He taught law in India. He taught law. He was professor and dean of Faculty of Law, University of Lagos. He was Attorney General of the Federation. He was, and then again, check the records. He was one of the finest jurists Africa has ever produced. He was also appointed Chief Justice of Nigeria, ultimately becoming the president of the International Court of Justice. And we have several Nigerians like that. Now, there are many brilliant, take for example, Emeka Chianu of University of Benin. Somebody who has, when you mention after Omotola, in terms of the Encyclopedia of Nigerian Law, these are the people who write the laws that we go and, adjudicate or we adumbrate in court. And you abandon them. The idea is this: the National Judicial Council should go shopping, should go shop for the best. And that's the reason why we had the likes of Nikitopi, who was once professor and dean in Faculty of Law, University of Maiduguri, in the Supreme Court. And you need to see the robust jurisprudence these men were given. And to think that you just elevate justices from the Court of Appeal just because they served their time, just because they belong to the establishment, and you will elevate them to the Supreme Court, you are denying the Nigerians of that long tradition of brilliant judges. I don't see any reason why members of the Nigerian Institute of Advanced Legal Studies should not be actually persuaded to come to the higher bench.
Because if you're not a lawyer, because if you're not a lawyer, we can still say they are flowery, cases and judgments, and these are the same people we still quote till date.
Yes, the reason is this. So when you crowd the court with only members of the establishment in the judiciary, denying the judiciary of the brilliance of researchers, where is Professor Tietie Ladan, where is Epiphany Azinge, where are all these guys? These are men who actually throw light on what is law in Nigeria. Now, if you now reduce the legal process, the adjudication process to mere technicalities without the flavor, without the flesh of what is nation building, as a policy court that should determine the direction of the court, and you make it to be just ordinary mere technicalities, you are actually affecting the destiny of the country. And I think it must be practicing lawyers too have been neglected. The idea is this: once you are able to persuade these men of integrity and high sound intellectual capacity to accept to come to the Supreme Court, these men will not do nothing but integrity. But when you appoint only men of ambition, men of career, who are at the point where they join the judiciary as judges aimed at the Supreme Court, you are headed for some very skewed judgments in the long run.
Frank Tietie, the point was made on the floor there that there were no petitions written against the nominees, the 11 nominees, and they possess the requisite qualification and experience to occupy the position. That's Senator Tahir Mongunu, Chairman Committee on Judiciary, saying there. But let's talk about one other thing that was raised on the floor, the need to review the remuneration, actually the budgets of the Supreme Court for 2024.
I think that statement from Ahmed Lawan was quite hypocritical. He was Senate president. He was administering the budget of this country. That is the Appropriation Act. For 4 years he did that. And then he comes to say something about the judiciary being poorly funded. In my own reasoning, I think that it is the remuneration of judges that we should address. I can tell you, judges, whether on the higher court or lower court, are actually suffering deprivation in terms of not having commensurable salary with regards to the level of inflation and the kind of pressure that is on their offices in terms of being approached all the time with bribes and then to be influenced. I really wish these men went through the confirmation process so that they will be asked that, look, what would you do if your father were to ask you for a favor, or if someone were to bring 100 million cash to you in dollars? What would you do? Say it to us, and so that we can understand. All of these things were not there. And when you tell me about competence, let's keep that aside, because these men did not write any exams. They did not show that they have any extraordinary competence intellectually more than the persons who have not been appointed. And I think that it gives a lot of reason to take another quick look for the urgent reforms that are required in the judicial process. And again, look beyond in terms of funding. Take a look at the real issue that the Senate President mentioned. Why do you crowd the Supreme Court with unnecessary number of cases that go there in terms of appeal? Why do we have so much latitude provided under Section 241 of the Constitution for such appeals as of right. That is, no matter how you feel, so long as you were able to twist it and coin it, that it's a matter of law, you go on appeal. You know, so clogging the Supreme Court like that. So and then you tell me it's a problem that money can solve. No, give adequate resources to a judge, make him feel so fulfilled that he knows that he owes God and the people of Nigeria the responsibility to dispense justice, and not be looking for favors from where he comes from, or for the people that control money, who are usually politicians. And that's the bane of the judiciary at this moment. That could have been corrected if the confirmation process was very tough and it went with so much scrutiny. Unfortunately, we didn't have that.
The Incorruptible Judge. I'm reminded of that book.
James N. Henshaw.
Thank you so much, Frank Tietie, for joining us on Newsnight.